committee hearing. Senator Dolezal, you had nothing going on today, probably bored. Welcome to the committee. Would you like to open us up in a word of prayer? Your mic 15, is that right? Yes, sir. I always try to surprise the person that looks the least prepared. That was you today. Mike's yours.
You definitely got me. Let's pray. God, we thank you for this day. It's not lost on us that you have given us the gift of life today. And I pray that we use it to glorify your name and honor you with the gifts that we've been given, both in this building and outside of it. I pray that your grace upon our day to day. It's your name we pray. Amen.
Thank you for doing that. As always, if you want to be heard on the bill, please sign up on the sign-up sheets. We have them up here. If you did not sign up and want to be heard, please step up now. All right, we're going to get started. We barely have a quorum, and people have to go, so we'll try to move as quickly as possible. And we're known for doing that anyway, so it should be easy. We're going to start. Are you laughing, Senator Albers? You were first on the agenda, but starting with Senate Bill 10, Senator Goodman, would you come up?
Mr. Chairman.
You're working off
of LC 442865, Senate Bill 10, and this bill, what it does is add another Superior Court judge's position to the Lapahall Circuit. Lapahall Circuit is leading with the highest caseload judge ratio at 1.42 in Georgia for a judgeship. The last time that a judgeship was added in 1979, and there's unanimous support from all of the 5 counties. This is the information. I know that we are time sensitive here. I think everyone has it on your committees.
Which counties are covered by the circuit?
It is Cook, Clinch, Lanier, Atkinson, and Berrien. And so I have also here with me Judge Clay Tomlinson, who is my neighbor. His son and my son are best friends. They are actually the founding members of the South Georgia Swamp Raiders duck hunting club. So anyway, he's here to answer any questions. But Mr. Chairman, if the committee does decide to pass this bill, I have a small amendment that I'd like to ask.
The Judicial Council recommended that this circuit have another judge, I'm assuming, as well. Okay. That's correct. Yeah. Where were you on the list with them, do you know?
This year we are the highest need with 1.42. The second under us has a 1.36 rating. And this is not the first year that we have qualified for an additional judge, but it is the first year that we've been rated so high.
All right, and the amendment you're talking about, will that be line 104 to make that January 1st, 2026? Is that what needs to be?
Yes, sir. Yes, sir. We'll take it any way we can get it, Mr. Chairman. Yes, sir.
Mr. Chairman, I have line 22.
As well?
Yes, sir. Line 22, scratching out July 1, 2025, and inserting January 1, 2026. And Mr. Chairman, did you saw, what was the other line you saw, Mr. Chairman? Yes, sir.
I said the wrong line. It was what you said. I was looking at the wrong date. It was just the effective date I was looking at. I think that date will stay July 1, 2025, won't it? Right. Okay. You're right. I was wrong.
Well, thank you,
Good
Mr.
job.
Chairman. I appreciate it.
It's nice how you corrected me, too. We have a question from Senator Calvert.
Thank you, Mr. Chairman. I got a couple, if I might. Judge, you probably can answer this better than the senator. How many judges in the circuit now?
We received our second judge in 1979, and we've been operating with 2 judges covering 5 counties for over 45 years. Since that time, our circuit has seen a 33% increase in population, and our caseload has doubled. We desperately need a third judge.
Explain to us what that 1.42 means. Translate that for us.
Yes, sir. The easiest way I can explain that to us is in 2024, my 5 counties moved or processed or touched about 8,000 cases. That's with 2 judges. So that's a workload assessment. I believe this is correct. The judge's workload is supposed to be between 0.8 to 1. If it's over 1.2, then your circuit qualifies for an additional judge, and we're at 1.42.
So that's just the average of all the Superior Court judges would be like a 1, and so your guys are overworked drastically.
Yes, sir.
Okay.
Yes, sir.
And I guess the other question I had is, do you experience a backlog or a waiting time for cases. I am getting hammered by judges all over Northeast Georgia. And it's like some edict from above said, get rid of your backlog. But nothing's older than 2022. I just wondered, do you got cases 5 years in the pipeline and you got to have help to catch up? Or
Yes, sir. Very good question. I want to make it clear to this committee that this is not a COVID issue. We do not have a COVID backlog. We are processing cases. What we have is an increased and sustainable increase of caseload on our courts for over a decade. So we do have some older cases, but that is not the norm. Generally, that's because of either attorneys retiring or conflict cases, those types of things. You know, some cases just drag out. Some civil cases take longer, but our workload is not due to a backlog.
so fair to say citizens are getting to court in a timely manner, but it's because y'all are working your tails off.
Yes, sir. Yes,
Okay.
There is no doubt multiple days a week myself and Judge Perryman visit more than one county. We have a 26% poverty rate in my circuit. My citizens cannot afford to chase me around the circuit. So I'll start off in one county in the morning, and by lunch I'm at another county handling a whole different docket.
Thank you so much. Thank you, Mr. Chairman.
Thank you. Senator Steele?
Thank you, Mr. Chairman. Judge, would you say that the increase in caseload is in part or fully the responsibility of the Goodman family?
Tell us about that swamp organization you were talking about.
There may be a slight increase in DNR tickets due to that issue, but it's nothing we can't handle.
All right. Any other questions from the committee? Leader? Okay. There's the appropriate time.
Recognize me. I would like to make a motion to pass for SB 10. And
We have a motion to pass SB 10 LC 442865 by Leader Gooch, a second by Chairman Cowsert. We have one amendment being proposed by Senator Steele. He wants to add on line 22, change July 1st, 2025 to January 1st, 2026. Is that your amendment? It is, sir. We have a second from Senator Dolezal. Any discussion on the amendment? All those in favor of the amendment, please say aye.
aye.
It carries unanimously. Any other amendments? All right, back to airline. Motion to pass now as amended. All those in favor, please say aye. Aye. Any opposed? It is unanimous.
Thank you, Mr.
Congratulations.
Chairman.
Good work. Thank you, Judge. Thanks for sticking around. It was a long day.
Chairman, members of the committee, on behalf of the citizens of the Lapa Circuit and myself, thank you for your support of this bill and the access to justice that it will promote in our communities. Thank you for your service.
Thank you. Appreciate your service, too. All right, back to the top of the agenda. Senator Albers bringing back SB 9, the bill we heard on Monday. He worked on a substitute, which we now have in front of us, and I believe you worked with all the parties that express questions or concerns about the bill. We have LC 492205S. Is that what you have?
Yes, sir. Thank you.
All right, the
Mr.
floor is
Chairman.
yours.
And I brought Mr. Robert Smith from PAC again with me. Before I begin, I'll be very brief, but I emailed a copy of the updated bill as well as all the responses to all the committee members yesterday. And I also sent a copy of this horrific article, which is just 7 days old, where a vendor for Georgia High School up in Gilmer County used AI to create nude images of children, kids, dozens and dozens of them. This is real. This is happening. And it's why this bill is so important. So in front of you, we made the minor edits of taking out the couple of lines that were more of a Scrivener's error. We did address the question of making sure that the minimum sentences, if there was already a minimum, that this didn't move that. And then I was going to, if it's okay, ask Mr. Smith just to talk about bifurcation and Romeo and Juliet, because both those questions were brought up. Again, this was emailed to everybody well in advance, but for your committee's edification, Mr. Chairman, if you allow him to speak for just a moment.
Basically, the question about bifurcation and the context we have usually is, for fairness, trying to keep certain immaterial, certain issues out of the request of the defense. In this, originally it was made mandatory. We usually, in context for felon in possession of a firearm, we keep the conviction out, so that way the jury doesn't know anything other than whether or not the person was in possession of a firearm, and then they're informed whether or not the person has status, so they shouldn't be in possession of a firearm to begin with. So we keep that out. I believe in this instance, we're doing the same thing because of the enhancement of the sentence, which you have to be able to prove beyond a reasonable doubt. As for the Romeo and Juliet provision, and in this instance, because we're in all the other instances when this body has put in the Romeo and Juliet provision, there's been some discussion about how the image came, or whether the conduct, there was some sort of issue of consent between the two parties. In this instance, because specifically for Section 1, there's no consent because there is no other person. The image is completely created by AI. You've got an intentional act of a person sitting down and typing into a computer AI generate this image based on these parameters. So there isn't an issue about whether or not the person came into the image through a consensual act or was engaged in some sort of consent with the victim, because in essence there is no victim. It's a computer-driven image, and that's why the Romeo and Juliet provision wouldn't attach in this instance.
You have questions from the committee. Senator Parent?
Thank you, Mr. Chairman. Thank you, Chairman Albers, and also always good to see you. And thank you for knowing so much more about the law than I do. I want to drill down a little bit more on the Romeo and Juliet. So, okay. So, could there be a situation where the boyfriend and girlfriend are chatting, and they're actually through texting there is consent to generate some image that is not actually of the girlfriend or what have you? Could that be possible? And if so, wouldn't that
we have other
have
crimes?
consent?
We have other crimes that would reach that.
Okay.
And
okay.
because there's already a Romeo and Juliet provision in place when you take an image and you manipulate it of a person that's identifiable. Also, when you've got two teens that are under the age of 18 are exchanging inappropriate images. I don't want to be too specific, but basically, when you're exchanging child pornography between two children, there is a Romeo and Juliet provision that y'all put in place already for that.
So essentially, that could be covered under something else, would it?
Yes, ma'am. This crime that's here is specifically somebody sitting down and saying to, one of the many different AI tools that are out there, I would like to see an image of a child in certain activities or in certain stages of undress, and the computer is then generating it, and whatever parameters that the person who's at the computer is giving, that's what's coming back to them.
Can I ask one more, Mr. Chairman? So the other thing I'm curious about is, so if Romeo and Juliet doesn't apply for those reasons, I note that you said there is no victim. So how does that work with, does this then have a mandatory minimum or something on a crime where there's no victim? And how does that make sense then?
There's no victim as in how we think of the person who owns a piece of property that's taken, or the person who has the property taken from them by force. They're still a victim. It's society in general that somebody wanted to have this image, but there's not a specific victim to wit and where we would name the person. Society's the victim here because of the conduct.
Understood, okay. But is it more severe under this than it is if you're exchanging pictures of a real person? And if so, how does that make sense?
I don't believe it is, because if I remember correctly, if you're exchanging pictures of a real person, that would be if we're talking about the felony version, not the Romeo and Juliet, taking that aside. I believe it's 1 to 20, whereas this is 1 to 15. And then if we make the allegation and prove the additional element, then the judge would start at 2 to 15. But once again, sentencing range is left up to the judges.
Thank you.
Any other questions for the committee for Mr. Smith or the author of the bill? All right, thank you. We also have Maisie Lynn Girton with Georgia Association of Criminal Defense Lawyers. Good afternoon.
Good afternoon. Thanks for hearing from me again. Just briefly on the unfortunately, I think I might be the one who framed this as the Romeo and Juliet issue in the bill. And after a couple of days, I've spoken to Senator Albers about this. I've provided him, and I've also provided you all with a proposed amendment, because it's not really about Romeo and Juliet. We call it that in 1612-100. We refer to that misdemeanor provision as Romeo and Juliet, largely because the cases that went up on appeal and caused that legislation to be modified were exchanges between children who were dating, teenagers who were dating. So it became Romeo and Juliet. This is actually that too, but certainly here, it's a much broader group of children, and it doesn't have to be in a dating relationship. So, for instance, let's say you have a high school wrestling team, high school cheerleading team, you pick whichever team you want. Two of these children decide it would be really funny to create a lewd, obscene picture of one of them. You use my face, put it on this crazy body. Or let's create it from whole AI cloth. Either it's gonna have the kid's face or it's not. It's not gonna matter. Either one of these is gonna be generated by artificial intelligence. And then wouldn't it even be more funny if we sent it to the whole team? So here we are. We've got children creating images, either with a likeness or without, arguably with consent or without, and now they're felons under this statute, versus what we've talked about several times, they'd be misdemeanants under 1612-100, when it really is a child who has consented to their image being taken. And that is a difference, and it's an important difference. And to your point, Senator Parent, I disagree with my colleague from PAC. This crime can be charged in the scenario you laid out, and it is very common for the state to stack charges. So if they were to charge these children under 1612-100 and charge them under this code section that's contemplated in this bill, yes, maybe in plea negotiations it would get pled down to the misdemeanor version of 1612-100, but it doesn't have to. They could still be convicted under this one. So it is a concern to us that we wouldn't build in protections for children. This would not build in a protection for the man that Senator Albers showed you the article about. That person is still going to be fully charged under this code section. I'm just talking about these children that are under 18 years old, behaving badly with underdeveloped brains in high school, that we all know it happens. Let's not saddle them with a felony in this context when we're not doing it in the other one. That's our only request. And I've provided language to each of you. As I said, Senator Albers is rejecting it, but I would love for you all to consider it, considering the entirety of the policy that you've created in this space for children.
It seems like to me your argument for your amendment is more based, though, on the fact that this is something an 18-year-old does or younger, where they're still a kid and it's just a dumb thing they did, right? Not so much Romeo and Juliet, where it's more based on a relationship that'll be fair. I mean, that seems like that's what your testimony is because you also have this line in here about they don't distribute it to somebody else. So it's like you give a little bit of a pass based on the age. Is that the basis of your argument?
It is the age, but it's the same in 1612-100. I'm gonna just grab that code section so I can say it properly. There is no requirement in 1612-100 that there be a dating relationship involved. It simply is that the minor depicted was at least 14 of age at the time the picture was created, and the person being prosecuted is under 18. So it could be between, and this could also, the other type of crime could be between non-dating children. So that's part of what I guess I'm sort of kind of hoping to correct the framing. I don't know that either one of these, we frame this as Romeo and Juliet because, like I said, and Mr. Smith said, the cases that went up on appeal were these consensually dating relationships that kind of framed the issue for you all to address. And when you did, we called it Romeo and Juliet because isn't it cute that these kids are sexting each other? But now that we're talking about AI sexting, they're felons. So I don't think it's only about the relationship, Chairman.
You have questions in the committee. Senator Tillery?
Thank you, Mr. Chairman. Macy, I have a question for you. First of all, I think that depicting a child real or drawn, this is just sick in a sexual nature. So I want to be clear where I stand with this to begin with. My question, though, is how old does one have to be charged as an adult in Georgia? Is it under this statute? 17? So if someone was under the age of 17 and did this, would it be a felony for them?
If they're 17, it would be.
Okay.
And then there are some transfer provisions within the code, and I would have to go look to see, but whether or not this would be transferable from juvenile court to superior court. But if it qualified as a transferable delinquent act, then yes, they could potentially be charged as an adult. But certainly every 17-year-old that's charged under this will be charged as a felon.
But if they were under 17, they would not be charged as a felon anyway.
They'd be handled in juvenile court.
So it wouldn't be someone who's 14 years old and does this, what we've already said is sick but stupid act.
No, it's the same person that could be prosecuted under 16-12-100, the same 17-year-old behaving badly and getting misdemeanor punishment is the same cohort of people that would then under this new crime be felons. It's the same cohort. You're right.
That's I guess what I was going to ask you is then where do you draw the next line? If you say 17 is young and stupid, is 18 young and stupid? Is
Well,
I think we've drawn the line pretty clearly for everything else that young and stupid stops at 17. Why should we change it for this?
Well, I would love for you to change it for many things, Senator,
Right.
Because brain science shows us that our executive functioning isn't fully complete till we're 25. We've had conversations about raise the age. There's lots of things at play here, right? I don't believe 17-year-olds should be charged as adult. I think that's a problem with our system. So I would like you to raise the age to 25 if I had my druthers, and then let's treat all the kids who have underdeveloped brains just like that. They're behaving because they don't have good executive function and they don't make good judgments.
Okay. But one more thing to point out, I think, and I want to make sure that I'm reading this correctly. Even if you're the 17-year-old, you have to be depicting someone who's at least under the age of 16 I understand to the reasonable observer.
Right.
Okay. So if 17-year-olds depicting someone who's 17, then 16, 12, 100's not triggered?
It is triggered. It's just that if they're prosecuted under 16-12-100 and found guilty, they will be sentenced as it'll be a misdemeanor. If they're similarly prosecuted under Senate Bill 9's crime, they will be sentenced as a felon if they're convicted. I'm just looking for equity, sir, for these for that one small cohort of children that could find themselves in this situation in both code sections. It's just equity for 17-year-old kids. It's no one else.
Gotcha.
Any other questions from the committee for Ms. Gerton? All right, thank you.
Thank you.
That's everyone that signed up to speak. Let me ask, you want to close it out and let us know your position on the amendment?
Thank you, Mr. Chairman. I appreciate you all listening to this important and ever-evolving issue. Thank you, Chairman Tilley, for bringing up that very favorable point. I appreciate Maisie Lynn and all the context she brings to all the committee meetings. But if we're going to draw the line on this, then we need to change the entire code. It's either 17 or we're going to change it to a whole nother age, and I don't think the posture of the General Assembly is to make that change this time. So rather than making it inconsistent, I'd rather we keep it consistent. And I also know that we've got great prosecutors, and of course, Mr. Robert Smith, who helped us out with PAC, who also give broad discretion. And I think they do a good job in working with individual cases and especially youth throughout the state. So I'd ask your favorable consideration for a due pass vote.
All right, you have a question for Senator Parent?
Thank you. Chairman Albers, I didn't really get a chance, unfortunately, given the long day we've had, to go through the substitute. I seem to remember that there was something about mandatory minimums in the legislation. Can you speak to that? So you're basically saying the prosecutors, if they see a fact pattern that sort of wouldn't warrant the felony treatment, you trust their judgment to not utilize it.
Well,
but then once conviction happens.
Well, prosecutors are going to end up charging them based on what they think is right. And we see charges pleaded down pretty regularly.
That's true.
So I have faith in that. But as relation to your question, we actually had a Scrivener's error in the original bill that it didn't account for other mandatory minimums, and it just said that this applies unless there's another one that's already in place. This would be in addition to. It was just continuity in it. We had talked about it at the meeting earlier in the week and worked with, well, I don't see, oh, there he is. Legislative counsel in order to correct that.
Just to be clear, I don't believe there's a mandatory minimum actually built into this bill.
Okay, thank you.
Any other questions for the author? All right, what's the pleasure of the committee? Motion do pass by committee substitute from Senator Redd, LC 492205S. Is there a second? Second from Leader Gooch. Do we have any amendments? We have Senator Parent.
I don't have an amendment. I'm just gonna make a comment before we vote.
Or do you want to make a comment on the motion then?
Yeah.
Any discussion?
Yeah, it doesn't seem, discussion, yes. It doesn't seem that the will of the committee or, you know, Chairman Albers or PAC is to move ahead with this proposed amendment by Gachtel. This is hard for me because I currently have a 14-year-old boy going on 15. And in my own house, I've seen the behavior, and yours are going to get there, right? And so will yours, Chairman Tillery. And so it's like strikes fear, honestly. It's like there's so much stuff where we didn't have to deal with what they have to deal with undeveloped brains and technology, and it's terrifying. So I'm going to be a no today. I need to think through this a little more because I understand your point as well. So that's my comment. Thank you.
Any further discussion on the motion do pass by committee substitute? All those in favor of the motion, please raise your hand. 7, I count right. 7 for, all 8. Sorry, miscounting. All against? 1. Motion carries.
Thank you very much,
Thank
Mr.
you.
Chairman and committee members.
I struggle with the count. All right, 7-1. You know, the excuse for not giving numbers. All right, one more bill. Senate Bill 12, last bill on the agenda. Senator again.
It was almost unanimous.
Almost unanimous. We are working off this is a bill we heard on Monday, another committee substitute. We are working off of LC 492218S. Is that what you have?
Yes, sir. Yes, sir. Thank you.
All right, tell us the changes you made from the last bill.
Well, and after listening to the comments and discussions from different groups, probably the biggest substantial change is in lines 20 through 29, and I want to specifically point out 28 and 29. Such private persons or entities shall be required to produce such public records to a custodian upon request from such custodian. And what we're talking about here is, you know, if you want information on where your tax money is being spent, what's happening, then you should make that request to the government entity with which spending that tax money. And when we do that situation, if a private company that's working for that public entity, then this spells out that, you know, that private company has to respond back to that entity. And I let my esteemed counsel, Rushi Patel, who's with me, address anything else that
You
that
paid
he
him by
wants.
the hour?
Actually, I can't afford him.
We discussed that.
No, you should.
Thank you, Mr. Chairman and members of the committee. As Senator again mentioned, we took the feedback we got from this committee and from the other testimony and basically redrafted the second section of the bill. The original version, while simpler, was dealing with the penalties area, and this is just doing a straightforward language change that says the records request has to go to the government, and the private parties who have the public records have to respond to the government to get that record to the government.
Right.
I would also note, it doesn't change the definition of what a public record is. It's the public record is like it is today. It'll be the same after this is done.
Just clarifies where the request goes and make sure that also a government couldn't hide documents through someone they contract with. It also confirms that.
Yes, sir.
Yeah,
Exactly.
Senator Tillery.
Thank you, Mr. Chairman. Thank you, Senator Ginn and Rushi. I have a question. Right now, is the way I understand open records laws, a local government could designate a employee to be their open records designee. Essentially, the request has to go to that person. So, if it's the county, maybe it's the county clerk, and we funnel everything through the county clerk, so we know where all the open records requests are filed. In your definition change, have you accidentally altered that?
No, because the process you're talking about is in Code Section 50-1871, and it's the process where the records request goes and how it's followed. So if you look at 50-1871, I think I have a copy.
You got that in Section 2, and you amend it. That's where I'm going.
Yeah, so it doesn't change who it goes to. So if you go to 50-1871, there is paragraph B1B says, a request made pursuant to this article may be made to a custodian of a public record orally or in writing. An agency may, but shall not be obligated to, require that all written requests be made upon the responder's choice of one of the following: the agency's director, chairperson, or chief executive officer, however denominated, the senior official at any satellite office of an agency, a clerk specifically designated by an agency as a custodian of agency records, or duly designated open record officer of an agency, provided that, however, that the absence or unavailability of the designated agency, officer, or employee shall not be permitted to delay the agency's response. So that language is left alone. The city or county still can designate that long list, and this doesn't impact that.
And you think that, again, I'm going to vote for your bill to come out today, but I want you to take a look at this later on, because here's why I'm voting for it. I understand what you're trying to do, Senator. I thank you for hearing our concerns earlier and limiting this down, making it true now that the request has to go through the government, and if the government has a vendor, then it's the government's responsibility to get those papers from the vendor and get it back for the open records request. I support that as long as the record is still open. What I'm concerned you've done, and you check me, is when you've now defined custodian in lines 10 through 12, and then you say on line 21, all requests to inspect or copy records under this article shall be made up on a custodian, that the wider definition of custodian takes you away from being able to specify. So just please look at that as you move forward.
Sure.
I want to make sure that you've not inadvertently gone somewhere that I think we fixed a few years ago.
Appreciate it.
Any other questions from the committee? All right, we do have two individuals. Thank y'all. You can step aside. Two folks signed up to speak in opposition to the bill: Tom Clyde and Sarah Brutenson Palmer with the Georgia First Amendment Foundation. Do y'all want to come together again? Welcome back.
Thank you for your time this afternoon. As I said on Monday, I'm Sarah Brewerton Palmer, president of the First Amendment Foundation, joined by Tom Clyde, who's also a member of our board, and an attorney with Kilpatrick Townsend, who represents the AJC and a number of other media organizations. I want to start out by acknowledging that the revisions in this bill have addressed most of our serious concerns that animated our letter that we provided to the committee and the testimony on Monday. We want to thank Senator Ginn for being responsive to those concerns. We do have one minor language addition or revision that we would like to suggest that the committee consider and that Senator Ginn consider, that Tom will talk about in a second. We've talked with our board members, open records attorneys, media organizations. As an organization, we remain opposed to the bill because we think that this change is unnecessary. And the system as it's designed right now seems to be working very well. From our understanding, news organizations typically start by going to the agency. They will often, if these records are held by a private company, get the response, we can't get these, and they will go to a private company. And our understanding from the AJC is they've very frequently had very successful experiences dealing with private companies, have, paid fees for records requests that involve staff time, and have found it much faster to get those records directly from companies than from working with an open records officer. This bill does, make clear that those records have to be provided to the agency if the agency is going to a company to get those records. But there are no timing requirements, and I think this will add some layers of complexity that I think are very likely to cause confusion and delay this process of getting contractor records pretty significantly from where it is right now. So,
is there timing requirements that we're changing with this bill?
So there are not, but the way that things work right now is that the person that is receiving the request has 3 business days to either give you records if they're readily available or tell you when they expect those will be available to give you a response to that. And I don't think that, so that will continue to apply to the agency, but there's no timing requirement on when a contractor has to give anything to the agency, because now you can't go to that contractor directly, and the 3-day rule does not apply to them in the same way that it does now. So I think it's very possible that this could become a pretty delayed process.
But the agency's requirement remains the same. They still have the same 3-day requirement with this draft, right?
To tell you, I'm gonna have to go talk to this contractor. Yes, they'll have that 3 days, but there's no timing on when they have to go get those records that aren't in their possession. So,
but again, that's not changed with this bill, is my point. If that's something you want to see in the underlying law, that's not a reason to be opposed to this bill, because it's not being addressed in the bill.
I understand your point.
Sure. So I'm Tom Clyde. I want to echo some of the points that Sarah has made. Number one, we very much appreciate the revision. It does address a lot of the major concerns. I do think the timing requirement is a problem, and you're exactly right. It's not changing the timing requirement. But when you get to give an Open Records Act request directly to a vendor that's being paid by with tax money on behalf of a government agency, then the duty to respond goes directly to that vendor, and that vendor typically takes it quite seriously. But there is one language change that I encourage the committee to consider, and I want to explain what that is, because I think it is entirely consistent with the goals, including the goals of the amendment. And really, I'm going to address what I understand to be line 22, and it's section 2 of it's creating a new A2. And so at line 22, it says, all public records requests shall be made only upon a custodian, and such custodians, upon receipt of a records request, shall be required to comply with the procedures of this code section, including but not limited to retrieving public records, thank you, from private persons or entities in possession of public records of that agency.
I think you're reading from the wrong version. Is that what let's look at the substitute. That way everybody's on the right line with you.
Okay. Yeah. Okay. So you've added that language. Thank you. Very good.
All right, good.
Hey, kumbaya. Are y'all now for the bill?
I apologize.
Can we get a neutral from the bill for the bill now?
Well,
No response. Okay.
we continue to believe it's going to create unnecessary friction in access to the records of vendors, but we also very much appreciate the change, including that last change.
Well, thank you for helping make the bill better. Appreciate your work on that. Any questions? Do you have anything else you want to add? Any questions for Mr. Clyde or Ms. Bruton Palmer? All right. Thank you.
Thank you.
No one else signed up to speak on the bill. What's the pleasure of the committee? Yeah, of course. What's your mic? 11?
Yes.
Okay.
I'm not familiar with the rest of the code. I haven't seen it in recent years. Current law would require you to be able to, would allow you to be able to do an open records request to any vendor that's doing work with the government, like cities or counties. Is there a dollar amount on that? Is there a threshold or any kind of contingency? Or is it, if I go to the hardware store as a water authority or a county government and buy $100 worth of goods, does that mean I can do an open records request at the Home Depot in my hometown?
As the current law states, and this is what impetus for the bill was, it's always been assumed you made that request to the government entity. And the Supreme Court was challenged with this case, and when they looked at the case, they said, well, the law doesn't define custodian or agency as not the private enterprise, but only to the government agency. And so for me, if you want to put somebody out of business, just start hitting them with open records requests, one after another after another. Any private enterprise, you could swamp them with it. And so for me, that was what the rationale for the bill was to protect private enterprise, not to do anything to make it harder to get information. And I do want to address one of the things that they said about timeliness of getting that information. I had a page today, said the grandson of Dink Neesmith, many of y'all know her in the newspaper business, said and I've talked to my local newspaper, and I said, in actuality, what I think will happen on this is it'll probably speed up the process, because if you send an open records request to a private company, they have no way and no knowledge of anything about open records request, and they're probably going to blow it off and not respond. Whereas what this does is it lays out that local government is going to handle that request and get the information for the person that's trying to get that information. And that's what we want to do, is we want to get them the information.
He's filibustering. Could you give me a dollar amount? Is there one, or is it
there's not a dollar amount on open records request.
Counselor Tillery, would you like to give your 2
Senator,
cents?
Is it not true that the current law says that in order to be subject to an open records request as a private company, that you have to derive 33 1/3% of your gross revenue from state or government contracts?
So the definition of agency includes private parties that get 33 1/3 from political subdivisions.
Right.
But
then to push back a little bit, let me say why I think your bill does make sense. Every hospital in Georgia would be subject to open records requests that should otherwise go through DCH or through a county health plan. Would you not agree? Because I do not know of a hospital in Georgia that's not deriving 70% of its revenue from Medicare and Medicaid. Maybe Wellstar. I'll give you one exception.
I had a rape crisis center that reached out to me on the bill, and kind of what was it? And I discussed it with yourself. And that's where, for me, we look at it. I'm not trying to make anything harder but easier to get information and who responds. And I'd ask for your consideration.
To be fair, we're not changing that part, though, Chairman Tillery, with the bill of the 33. So that would still qualify as an agency, I believe, under the code.
That's right.
So we're not changed. So an agency would still be the same definition we currently have. Am I right on that?
That's right.
So
Exactly.
your example of like Wellstar, that doesn't change this. My understanding of this
It would
is
still be subject to a direct.
we did not change. Am I right on that? We're not changing the definition of agency. You're just changing it to where you're clarifying that when you are an agent, if you qualify as an agency, that's where the open records request has to go, not other people you contract with. Does that make sense?
It's even smaller than I thought.
It's even smaller than you thought.
Thank you for letting me back on duty and teaching me law.
Yeah, it's about time. Glad you're getting to experience a little bit of law for once. All right, yeah. Any other questions from the committee? What's the pleasure of the committee? Motion, welcome, Senator Watson. Motion to pass by committee substitute LC 492218S from Chairman Watson. Is there a second? Second from Senator Rett. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. I don't have to count this time. So thank you for your work and hearing our concerns quickly and getting the bill done.
Thank you very much, Mr. Chairman.
With that, we're adjourned. Thank you.